Once again, a very good evening to all of you. I, Dr. Janita, extend a warm welcome to all of you on behalf of the entire team of School of Virtual Forensics. Keeping in mind the paradigm shift in education and training that the world is currently witnessing, School of Virtual Forensic was conceived as a virtual education platform in the field of forensic and all its alliances to aiding in legal and criminal investigation. We aim to accomplish this through online webinar, virtual practical session in conjunction with virtual viable meetings, and aptitude advancement training, all delivered verbatim by stalwarts in the field. Just before starting the webinar, I would like to give a disclaimer. Today's online webinar hosted by School of Virtual Forensics, and any information and or material contained in this webinar for general information are purely educational purpose only. The webinar aims at bettering the science and imparting knowledge to the participants and viewers. This webinar is for non-profit purpose only and should not be made the basis for business, legal, and any another decision. And also, I would like to thank all the mentors for helping us with this webinar sessions, organizing all the webinars, and thank you all of them. So moving on, today we have Dr. Dhwani Patel. Ma'am is an academician with a combination of dentistry, law, and forensics. A graduate in dental and gold medalist in law with post-graduation degree in forensic odontology. Ma'am has teaching and research experience of more than 5 years. Publication in national and international journals. Ma'am area of research is in human identification, bite marks, medico-legal cases, forensic pathology, and microbiology. Today, ma'am will be enlightening us with the knowledge on the topic Introduction to Law in Forensic Evidence. Now, the platform is yours, ma'am.
Good evening, everyone. Thank you so much, Dr. Janita, for such a lovely introduction. I'm very grateful to School of Virtual Forensics to arrange these sort of webinars, and I'm very obliged that I'm a part of this wonderful series. And it would be my pleasure to share my knowledge and a bit of my expertise to all the participants. And it would be, very good to know if any doubts or questions related to whatsoever I explain. And I'll be very happy to solve them. As she said, we can have a little of interaction later on after the presentation is done. So should I start, Dr. Janata?
Yes, ma'am. Absolutely, ma'am.
Yeah, thank you. Is it visible, Dr. Janita?
Yes, ma'am, it's visible.
Okay, so let's start with our webinar today. Already Dr. Janita has given a lovely introduction, as I said before, but before starting, I would like to tell something about myself. So as you all know, I'm Dr. Dhwani Patel. I work as an assistant professor in School of Forensic Science, National Forensic Sciences University, Gandhinagar, India. So basically, why have I decided to, introduce law is because I'm a graduate in dentistry and in legal, that is law. And because I wanted to pursue further with medico-legal area, mainly negligency, malpractice. And that's the reason the combination of dentistry and law is always the one of the main one. I post-graduated in forensic odontology, and gradually I came to know that it is a trioid, like a dentistry, law, and odontology goes hand in hand. So basically, as you can see the title, forensic science is incomplete without law, and law is incomplete without forensic science. And that's the reason it is very important to introduce law to whosoever is interested in forensic science. So to move further, why are we attending this webinar, or what will you gain after we have finished our webinar? So the first and foremost thing which you all will come to know after we are done is how and what is crime labs, that basically the forensic scientist labs, and its functions overall according to the law point of view. Rules of evidences, basic type of law which our criminal justice system delivers, how the legal method and knowledge is used to solve the forensic problems. different works done by forensic scientists and the experts which they consult. So these are few points where by the end of the presentation, probably everybody can answer, which will be very helpful for their forensic science practice. So to start with, what is forensic science? Forget about law and just concentrate on what is forensic science. So forensic science is an application of science to the law or legal matters. Basically, it is that scientific discipline that functions within the parameters of legal system. So, if I can just tell you in a layman language, forensic science is handicapped without legal system. It cannot function without legal system, and I would say vice versa too. Legal system is also handicapped without forensic science. You cannot move ahead even one step further if both of these individually works. They have to work in a collaboration with both the rules and regulations which are being followed. And that is the reason we have to, and it is very important to understand the legal matters. Basically, forensic science guides the court. So whenever there is a case in the court, how will the proceedings move ahead? How will it move forward? The very next step is being the guidance that is being given by forensic science. Unless and until there is no forensic, the court is actually blind to move ahead because they do not know anything about the crime scene. They do not know anything about the suspects. They don't know anything about the evidences. Who are they to decide whether they are a criminal, whether they are guilty, non-guilty? Forensics tells them. Forensic guides the court to go in which direction and in which not. Basically, forensic science gives accurate information on whatsoever the matter is. A very detailed accuracy and precision is being given by forensic science to the court, and the court relies on the matter which is being given by the forensic science. In short, forensic science is being regulated by law, both statutory and decisional. So basically, when we are talking about law, as you all know, we are different countries. We have different, areas to explore. So basically, every law system is different in different places. If you learn law somewhere else, you cannot apply or imply it at some other place. You have to know the legal matters of that particular place at which you are solving the crime. For example, I stay in India, but I work somewhere else across the globe, but I cannot use my fundamentals of legality or law in some other countries because every country has different laws, has different regulations, have different systems. So you always keep in mind that wherever you work, you learn about the legal matters before you move forward. Otherwise, it's like in legal word, it is say that you are unknown to that area. Even if you are a graduate or a postgraduate in a particular branch or system, but if you do not follow the rules, regulations of that particular country, you know nothing. So how good you are, how bad are you doesn't decide, but how knowledgeable you are is what matters. Scientific analysis can be admissible only if lawfully done. So again, a very important point where law plays a very important role scientifically. So we all know that what are these reports, what are these analyses, what are these scientific evidences. So all these things are just a piece of paper or a piece of thing if it is not done lawfully. So if you do not do things legally, even the bestest thing would be the worst things. So as I said, even the best work if you do in your field without legality can be rejected by the court, can be rejected by the system, immaterial wherever you work. This fundamental thing works everywhere across the globe. So even if you follow the rules regulation of your organization probably, or you follow the rules regulations of your ethics, but if you do not follow legal matters, even the bestest work is of no use. Evidence is also, if it is not been collected lawfully or legally, it is not admissible in the court. So even if you get the best of the evidence which is proving the direction of any case, but if it is not taken, collected, or proceeded in a lawful manner, that evidence has no importance in the court of law. And that is the reason we are going to study that in every step of forensic science, legal plays a role, and what we have to keep in mind by doing that particular role. Now we move ahead little bit with the Constitution of India. So now, how will you come to know about these laws? How will you know about these legal matters? So there are sections, there are acts, there are procedures which you need to follow, which is there in the constitution of that country. So today, basically, because I belong to India and my graduation is on Indian law, so basically I'll be talking more about India, but the same thing can be followed by any country with minor changes according to their law system, which altogether is another topic which is known as international law. But that is altogether a different part which is not constituable in our Constitution of India. So there are Indian Evidence Act, there are Criminal Procedure Code, there are Indian Penal Code, there are certain acts like POSCO Acts, Motor Vehicle Acts. All these acts have certain rules and regulations which are bound to be followed, which gives you a direction to work in your crime area, and which will legally and lawfully make your things acceptable in court. All the rules and regulations have been described in this constitution. So whenever you feel that you are going somewhere wrong, which is not lawful, then you can go back to this constitution. You can just find what legal things are there and you can act accordingly. Now, what happens when we don't follow these things? Okay, the evidences or the whole case gets destroyed. That is one thing, major thing. The second thing is the person who doesn't do things legally is also bound to punishment. So you are actually, you are disturbing the system. You are, creating certain environment which is unlawful. And because of that, even if you are the highest authority in forensic science, you are owed to have a punishment for that. Forensic science, in short, is also known as criminalistics. So basically, forensic science deals with more of criminal things, more of criminology, which is the application of science to criminal and civil laws. Now, because we are talking about laws, I will just brief you that there are many laws. Okay, it deals with criminal, it deals with civil, it deals with property law, it deals with business laws. So there are numerous laws. But if we talk about forensic science, that we all are talking about, and we all are forensic people, we mainly focus on criminal laws because criminology or criminalistic is something which goes ahead with that of forensic science. Many criminal investigations as governed by the legal standards of admissible evidence and criminal procedures. So basically, your criminal investigation is being governed by the legal standards of admissible evidence and criminal procedures. So unless until you do not know that which evidence is admissible, which criminal procedure is into it, you cannot perform your criminal investigations. And that is the reason we have to understand what criminal law is all about. So let's understand what is the difference between criminalistic and criminology. The scientific examination of physical evidence for legal purpose is known as criminalistic. What is criminology? It includes a psychological angle studying the crime scene for motive, traits, and behavior of interpretation of these evidences. So basically, it goes hand in hand. If we are talking about scientific examination, it also deals with criminalistic for legal purpose. If we are talking about any physical evidences which we are taking into consideration, it has an angle of legal purpose. If we talk about criminology, any angle, as in any motive, any reason, the behavior of the suspect or the behavior of the victim, which involves everything around Along with legality comes in criminology. So basically both goes hand in hand and both has the same area of exposure which it has to go legally. Now let's start. Let's start with whatsoever forensic science is dealing with. How will you start your work? The first work which comes into the picture for any case, it can be a civil case, it can be a criminal case, XYZ case, it starts with FIR. So unless until there is no FIR, no case would move ahead. And that is legal thing which we have to take into consideration. So what does FIR stand? FIR stands for First Information Report. We all know this terminology FIR, but how is it important forensically and legally? That is what we will be discussing. So a report given to the police, the first report which goes to the police by any random person who knows about the case or the crime is known as FIR. So this FIR is either orally being given, can be given written, and it has to be written or an entry has to be made in a registered in a police station. Of course, FIR is the first step, but it is not a legal document. FIR means it has authority, the police has an authority to start any investigation, to start any case. But legally, an FIR which is written is not considered a legal document. For example, whenever there is a case in the court, of course, the first thing comes in the court is the FIR. But whatsoever is written in the FIR is not something which the court follows because that is the first information. There is no investigation, there is no research which is being done on that case. That is the reason FIR or whatsoever is written in the FIR is not considered to be legal. The report on the criminal information is not an important evidence. The FIR is considered to be the first step, but the information which is being written is not considered to be an evidence. It is not a reliable source. But even if the report, even if the FIR is delayed, the case of the prosecution or the case doesn't become weak. So even if the incident or a crime which has happened today and the FIR has been registered after maybe 2 months, that doesn't mean that because it is a delayed FIR, the case has become weak. So whatsoever is the situation, whatsoever is the condition, FIR is the first step in forensic criminology, if I said, or in crime investigation. Next comes inquest. What is an inquest? An inquest is an inquiry or investigation into any crime where a bodily injury is involved or a cause of death of any individual. So this inquiry is the second step that involves the investigation. Now, when an FIR is being made, an inquest is being made either by the police or magistrate in India, and an inquiry has been set. The inquiry is being led by the investigating officer. So basically, an investigating officer is there. He will, start with the inquiries. He will start with the investigation of the cases, and that is how the whole procedure of the case goes ahead. He would be the first person who will be having a team of people where this whole team will go to the crime scene and perform the investigations. So now an inquest is a legal inquiry. So as an FIR is not a legal document, inquest is definitely a legal inquiry because whenever you go for any investigation or any inquiry, the first thing which you need to show is your documents, your legal documents, that is your permission to investigate that particular crime scene. So an inquest is a legal inquiry into any circumstances or the cause of the death or the bodily injury which has happened suddenly, suspiciously, or in some unnatural manner. So all this thing leads to the crime scene. So now the team of investigating officer, which involves 2-3 police officers along with the investigating officer and a team of forensic scientists. So all these people together go to the crime scene and start their work. So now we understood, how legality plays a role till here. Now we'll move forward with the crime scene investigation. So our third step would be inside the crime scene, on the crime scene. Now, because crime scene is one of the most important feature, I would say, in the whole procedure, you have to follow certain rules and regulations. You can just not randomly go ahead and just move around the crime scene because legally it is not correct. If you are found to do that, you are bound to be considered, you are doing contempt to the court, to the procedures, to the rule of regulations, and you are bound to have a punishment for the same. You cannot deny that because law or court is not present on the crime scene, you can do whatever you want to. Why we cannot do all these things, or why is the court very keen on knowing what happened on the crime scene, is because every evidence is, every person who's there on the crime scene is answerable if there is something wrong which moves ahead. So all the documents produced for inspection of the court are termed as evidences. So now what the evidences or the documents which you procure or which you make during your crime scene investigations are legal documents. So what are these documents? What are these legal papers? So it will have the date, the time, the team, when did that team go, where did that team go, what time did that team go, whosoever were present in the team, their qualification, their designation is all what the legal report consists of. So basically, if you are a team of 5 people, everybody's detail is there in the documentation and every person's role. For example, my forensic sciences scientific team has one fingerprint expert, one serological expert, one odontological expert. So all these people have a designated role. That fingerprint expert will only correct the fingerprints. So whensoever there is something wrong with the fingerprints is in question, the court will directly ask this person that what was the scene and why were these things went wrong. So basically now everything, even a smallest thing which you see on a crime scene, you have to note it down on your documents. With the failure to do so, you are bound to get the punishment through the court because that could be an important evidence which you have missed. So why would the whole team be responsible for the mistake of one? And that's the reason every individual who's there on the crime scene will maintain these documents. The value of evidence has to be understood before its submission to the court. Now, before entering the crime scene, we do not know what evidences are good or which evidences are of more value or less value. So what as a scientist you might do is you collect whatsoever you feel is an evidence or you feel is a substance and you collect it, because once you collect it, the crime scene might get destroyed, the crime scene might get contaminated, or you cannot just go back again to the crime scene to collect whatever you have left behind. So what is the best thing you do is you collect as much as you can, even if it is good, bad, or less valued or more valued. Just collect it so that at the end of the day you have everything what is there on the crime scene. So that is the reason we have to be very sure what we are collecting, because all these collected items will move ahead to the labs, and then from the labs it's going to the court. The court might question its value and then will consider its admissibility. Questions to be taken into consideration is, like in the documents or when you are having a cross examination during your in proceedings, who, when, what, where, and why. All these basic questions should be there in your document. Notify the date, time, the method of notification, information received about the crime scene or about the, the whole case. You need to mention it. The means of transportation, as in, how many people went there, when did they go, persons present at crime scene, etc. You should have a proper scene description. So, as I said, you will not always have the crime scene at the place, and that is the reason proper scene description is something which is very important. Apart from the description, the first thing which is very important and of a very evidential value is, of course, photographs. If you fail to take the photographs, then you do not know your work properly. Because that is the first thing which the court takes into the consideration as an evidence, because that is the only thing which will replicate a crime scene. Victim's description, if there is any victim there, or if there is anything which you've seen as in maybe a dead body, you can always say that, how, in what condition, in which way, what sort of clothes, if there is any secondary identifiers, etc., should be mentioned. Next is crime team information. As I already said before, the information of all the people who are there with you as an investigating officer, you have to write it down. So these all things have to be taken into consideration, because all these things at the end of the day in the court will be questionable. Next comes evidence. Now you've already entered the crime scene, you've started making your documents, now comes the evidence. What is evidence? Anything that can be used to determine whether a crime has been committed. So you should know that, all these substances are very important to determine that a crime has taken place, or your considerate substances which is to be collected. Evidence is basically divided into numerous categories depending on its characteristics and reliability. So basically, it is divided into categories. Okay, so it's not that everything is evidence. You have to term it that which sort of evidence you are talking about. So let's move ahead with sort of evidences. Just to brief you about it, it's direct evidence is that the established fact which is seen, which is there, which cannot be changed. Circumstantial evidences requires a judge to make an indirect judgment with that. That is the circumstances which prove that yes, this is an evidence. Physical evidence could be any non-living or inorganic things like fingerprints, shoe print, paint, glass, drug, firearms, bullets, explosives, anything which is, non-living is termed to be physical evidence. Next is biological evidence, which all are organic things like blood, saliva, urine, semen, hair, any botanical material is considered to be biological evidence. Why we are taking into consideration these categories is because through these segregations, it will be easy for us to transport these particular evidence to that particular lab where the analysis will take place. Now comes collection, handling, storage, transportation, and analysis. One of the most important part when you are there on the crime scene, because this will determine the longevity of any evidence. Evidence you've collected, yes, it's good. It's in a very important substance which is deciding the case. But now, what if you do not collect it properly? What if you do not handle it properly, or what if you do not pack it properly? Then legally you are destroying the evidence. Basically, indirectly, you are doing something with the evidence which you should not do it. Even if it is knowingly or unknowingly, in the legal eyes, you have destroyed that evidence. So proper collection in the matter of legality is very important. When you collect it, you have to properly label it with date and time. Why is this date and time important legally? Because if there is something wrong in the analysis, we should know that where is the problem, where is the things going wrong, where is the chain going wrong, and whosoever is responsible, they are supposed to face the legal consequences. Why am I deciding or forcing so much on these individual words is because all this procedure involves too many people, too many handling of things, because this is not one man job. It takes an army to solve a case. You have people at every stage who will be concluding things for you. So even for the court, though court is one entity, they have to go from first section to the last section to know that where things have gone wrong. If they cannot figure that out, they might, call you, summon you to the court to figure out where things have gone wrong. So, in order to avoid these sort of questions, you have to properly do your work. So, proper labeling, time, and date is very important. Decide the collection according to the sample. Now, once you've decided your sample, that this is the evidence which you want to collect and take it to the lab, you need to know where you have to store it, as in what you have to pack it. Unless until you do not know, you are contaminating the evidence. You are indirectly causing the evidence to contaminate because it will not be properly stored in the bag which you have put it. So you should have that particular knowledge. So at times when we are studying, we think that no, these things are okay. We will understand as and when we do practically. But unless until you do not know your theoretical things, practical things will not come into the picture. So if you contaminate the evidences by properly or improperly storing it, indirectly you are under the radar of the court. Handling and transportation are the most crucial part. There are many cases, okay, I would say many cases across the globe where these transportation and handling of the evidence were not properly done, and because of that, the whole case was destroyed. As in, the person who was guilty was being proved non guilty only because of these transportation and handling issues. Documentation. So again, being a legal person, I always prefer that documentation is something which is very, very important. Paperwork comes into the picture at every step of point. If you do not consider it properly, then things will go in the wrong direction. Just a second. So basically, paperwork, documentation is something which should go very properly, in a very proper filed in a very proper manner. So basically, on the time of delivery, all these documents, all these paperworks are supposed to be exchanged, are supposed to be looked upon so that you do not make any mistakes while delivering these things, transportation of these things. Again, now whenever you have collected your evidence, there is certain duration of time through which you have to send it to the lab. If you are unable to do that, of course, for some important reason, you should know where you have to store your evidences. When I was working in the labs, I got some few cases in across that there were things which were rotten. The evidences were in such a bad condition because proper storage do not take place. So then, if these things happen, what will you answer the court? Will you say that you forgot to store the evidences? Will you say that you've got the rotten evidences? So you don't have any answer to the court, and court will definitely ask you questions if these things go wrong. After all these steps comes the laboratory analysis, and then comes the report writing. Okay, we will definitely go on report writing once we finish this chain of custody. So again, the chain of custody is one of the important thing. An item which is properly handed through an unbroken chain of custody is required because the whole chain of custody is what the court requires. Proper demonstration is necessary in the court from the time of being obtained to the time it has been sampled. So basically, the court looks for all the details of these evidences from the time it has been collected to the time it has come to the court. If there is any gap which leads to some loopholes, you need to prove. Okay, you need to prove why these gaps are there, why there is a broken chain. And whosoever breaks this chain, again, as I said, is liable for punishment. There comes a question of relevancies. Now, what is this relevance? Okay. Now, whenever you submit an evidence in the court, there comes the picture of relevancy. There comes the picture of, its identity. Even it comes when you are exploring this whole analytical part. How relevant the things are, how important it is, because every evidence which you've picked up is not relevant to the case when the case moves ahead. So the court decides whether this evidence is reliable, relevant or not, and that is only it has been taken into consideration. If the chain of custody doesn't prove, the evidence collect will not be of any relevance. So if there is any breaking or gaps or loopholes in your chain of custody, definitely there is going to be no relevance of value of that evidence. How so important is that evidence? Stamp and seal is something the court always look for, because if there is broken seal or broken stamp, it means that it has been hampered, it has been misplaced somewhere with the seal things, or it has been exchanged, changed, or contaminated in the duration of this chain of custody. Again, signatures and details with all the proper paperwork is always the best thing what courts look for. So basically, crime labs, you all know that I'm not going much into these laboratories, but there are certain rules and regulations which the labs have to follow. That once their samples get entered, it has to be analyzed with all the paperwork which are to be done. Again, it has to be sealed, and then it has been existed out of the lab to the police or to the court, depends on whatsoever the case is. So anything which goes wrong in this, the person, the forensic scientist person who's dealing with that particular sample is responsible to answer. Analysis, caution has to be taken properly. There should be no cross contamination, because cross contamination can give you multiple results with multiple answers to one question, which is again of no use to the court. Timely report should be submitted. This is very important, because delaying in submission of the report might delay the consequences of the case, might delay the time of the court and that particular case. Now there is one thing, destruction of sample. Now imagine if you have a sample which you just want to destroy it completely for testing. For example, if I talk about tooth, as I'm an odontologist, what if I want to destroy the whole tooth for my analysis? Am I being permitted to do so? Yes, you are. You are permitted to do so, but with special court's permission. Because once and foremost, you are destroying that evidence. And if your results are not fair enough, or maybe if you do not get out of anything out of that particular evidence, that evidence has already been destroyed. So you have to show the importance of destroying that evidence for the analysis to the court in order to get the permission. If you fail to do so and you destroy the evidence, the defense lawyer can prove that whatsoever you have done is unfair. It will not be considered to be transparent, as in the case result might be considered inadmissible. So all these things have to be taken into the consideration if you want to prove that the analysis which you've done is proper. And if destructing the whole samples, you need special permissions. Evidentiary admissibility of the court. Scientific evidence is expert evidence in form of fact and in form of opinion. It should be related to the crime. All the substances are not evidences, and value of it should have judicial importance. So whatsoever you do should have an evidentiary admissibility rules. So basically, as I said, all papers are not legal. All evidences are not admissible. So you have to be very sure that the way you write, the way you deal with the things are the same which you follow with law, so that you make those things admissible in the court. So for example, if you are a forensic scientist, okay, let's finish this admissibility. One more slide. So basically, scientific evidence is allowed in the courtroom if it is generally accepted by the relevancy. As I said, relevance to that case is important, and if it is acceptable. The evidence is judged in the trial, and the judge decides if it can be used as an evidence or not. So basically, the lawyers put forward all your evidences and all your reports which you have given, but the judge decides its relevancies and its admissibility in India. Admissibility is determined by whether the theory and the technique which has been taken into consideration, whether the science has been offered any peer review. So whatever literature review you've done, that should be taken into the consideration. The rate of error which is acceptable, the method and its widespread use, whether the opinion is relevant to the issue or not. So at times, your opinion as a forensic scientist is something, but the question which has been asked by the court is not relevant to your opinion. So it is not admissible if it's that the case. The judge decides if the evidence can be entered into a trial or not. So in India, the whole responsibility is on the judge to decide something, and as a lawyers it's their duty to put forward things, and as a forensic scientist you have to give them something to put it forward. So that's how the whole scene is. Now comes the forensic report. Now, as a forensic person or as a forensic scientist, you've analyzed few things. Okay, when you analyze few things, you need to document it. The documentation which you do, as in the return part which you do, it is not an ordinary document. It is the most legal document to be taken into consideration. Therefore, proper documentation is very, very important. It should have everything which you have done in your lab and your opinion about the samples which you have analyzed. So basically, it should be in proper format. Now, what is this format? There is no legal format which is being given by the court, but you have to follow certain procedures in a documentation. For example, your designation, your name, your personal information. Then comes the whole sample details. What is the sample? When did you receive the sample? In what condition did you receive the sample? What do you want to do with the sample? Then comes what you did with the sample, okay? The method, the literature review, the procedure, the whole investigation, as in the whole analysis which you've done. Then comes the result and your observation. That these are your results. From this result, you are observing something. And then comes your conclusion. Conclusion is something, I would say, an answer to the question the court has asked you to say. Whenever an evidence comes to you, you are not the person as a forensic scientist to decide what you will do with this evidence. It always comes with a question. It comes with the question that how will you or what do you want from that evidence. So whenever you are clear with the question, you decide the analytical part of that particular evidence, and then you decide the substance, and then you decide your conclusion. So your conclusion is the answer to the question which has been asked to you. And then comes your signatures. Now, whenever I'm talking about expert report, there should be a copy of these reports. Why? That will come when I'm explaining the forensic expert. Now, what is a forensic expert? Witness. A witness is a person who gives testimony in the law of court as a regard of fact with the inference that can be drawn. So you are an expert who prepares that report. So indirectly, you are known as an expert, a witness expert. So basically, when you are being called to the court, you have to answer that what have you done to the evidence and what have you proved out of that evidence. So whenever you are being called to the court or whenever your paper as a report is being studied, you should always make a 3 copy of whatsoever you've done. So basically, this 3 copy is one for your personal use, one for the court, and one for the organization where you are born. So whenever you are being called or summoned to the court, you should have your personal copy with you, which the law gives you the permission to do so that you can see and read and answer to the court whatsoever analysis you've done. You can even take all the records which are there pertaining to that case to the court. You can take x-rays, you can take reports, you can take photographs, anything as a document which you want can be taken. So, of course, importance of photographs, I've already explained. The first and foremost things are the photographs. Maintain the confidentiality as an expert. You should always have that ethics to maintain the confidentiality about any case, how big or small it is. Be modest and dress properly because it's the legal thing. It is a court of law. Never pretend to write or assume something. Always, be confident enough to answer whatsoever analysis you've done. Learn to say no, because if you if you disagree on something, your opinion matters. Do not hesitate to disagree. As I said, if you have analyzed something which is giving something which should not be there, then also you should not disagree to whatever you have prepared as your report. Don't start volunteering the information, as in whatsoever is asked, answer that only, because that is very important. Duties of an expert: you should always be non-biased. You cannot be biased to any of the party which are fighting the case. You should not be under the influence of anybody, neither the judge, neither the prosecution, nor your lawyer. You should never omit the material facts, because all these things are there in legal. It's all written. If you do all these, it's contempt to court. Never try to be a lawyer. You are an expert. You are not a lawyer to ask questions. You are there to answer the questions which is according to your expertise. So that's the thing which you have to keep in mind as an expert. So yeah, I would be ending with this thing that, whatsoever you do as an expert, or I would say as a citizen of your country, you should know the legality, you should know the law. Otherwise, it will not be good for you, because you will be liable for punishment if it is wrong in the court of law. Yeah, so I'll be ending this. I have given my email ID. So in case if anybody wants to get in touch to me for any sort of reason, can definitely do so.
Thank you so much, ma'am, for this was a wonderful lecture. Legal part is something which is the core area of every forensic expert. So
Yes.
this was a very wonderful lecture.
Thank you so
We'll
much.
just wait for a couple of minutes. If anyone has any question, they can
Sure.
directly ask to ma'am, or you can put your questions in the chat box.
Sure.
Any queries from participants? I think, ma'am, your lecture was it was in very layman language that everyone understood that.
I hope so, because I tried to, because legal is something that it's difficult to understand with certain terminology. So I made it in a layman language so that everybody can understand. Even if you understand, then considering the law portion would be really easy. Yes.
Definitely, ma'am. Till then, ma'am, just one token of appreciation from the School of Virtual Forensics. Although it is a virtual webinar, but appreciation is must. So I would like to present certificate of appreciation. I hope it's visible, ma'am.
Yes, it is. It is.
Thank you
Thank you
so
so
much,
much.
ma'am, for taking out time, ma'am. Although it's weekend, I know, but thank you for taking out time, ma'am.
It is actually my pleasure. Thank you so much, School of Virtual Forensic, for making me a part, and I'm obliged. Thank you so much.
Ma'am, there is one question.
Yeah. Okay.
What sort of questions can a forensic expert expect from defense lawyer?
See, defense lawyer always comes into picture when it's during the cross examination. So basically, depending on the case, the cross examiner, as in the defense lawyer, will try to bring the report which you've made in a wrong way. They'll definitely try to bring you down. They'll always try to confuse you that whatever you have prepared as a report is either wrong, it's either insufficient, or it's either the other way around, which should not be. So if these are sort of the cases which you ever face in the court, You always have to be very determined, very confident enough that whatsoever you have done is properly done, and it should not lead to any confusion, because that is the work of a defense lawyer, to always confuse you, always portray something which you've not done in a twisted form. So try to understand the question properly, try to understand the meaning of that question. You can take your own time, understand the question, and then reply. Probably reply in a sentence that would not lead to another question. Like what we do in vivas, always be a straightforward question without any confusion. I think that would end the conversation with the defense lawyer. Yeah.
Thank you, ma'am.
Right.
Ma'am, another question is, how reliable court of law accept the scientific evidence of forensic science, whether it depends on the cases?
Can you come again?
How reliable court of law accept the scientific evidences in court?
What I'm trying to understand through the question is, how do the court accepts the relevancies of the evidence?
Yeah,
Okay.
evidences. Yeah.
So basically, when the whole case is being portrayed to the judge. So as I said, from the FIR till the analysis part, the whole file is being given to the judge first. So when the judge reads the documentation, the judge will consider or take into consideration all the evidences which are there in the report or which is there in the document. So if there is something which is not relevant, for example, just to understand with an example, if there is a vegetable somewhere on the crime scene and you have taken that vegetable into the consideration as an evidence, but when the whole case comes to you, you see that that vegetable is merely a substance and it has nothing to do with the case, then the relevancy is not taken into consideration. As in that particular substance is not considered to be an evidence, but it's only considered to be a substance which is being collected by the investigator. Because whenever we collect the evidences, the investigating officer doesn't know that how the case will move ahead. So the best thing what these people do is they collect as much as they can so that they do not regret it later. And as a lab person, as a forensic person, we deal with every analysis which comes to us without knowing where the case is moving, because the actual scenario of the case will be there in the court itself. So whenever the lawyers are discussing any evidences, the judge can deny that the substance is not to be taken into consideration, and that is how they decide whether it is relevant or not.
Ma'am, another question is, will FPD and CD are accepted as evidences in court?
FPD and complete dentures, that is what. Oh yeah, of course, why not? Because they are considered to be unique to that individual and they give an identity. If there is any denture markers on any of them, then of course it has a great value. Of course, why not? Anything, even a smallest thing of the body part or any secondary identifiers like your chain, your jewelry, your tattoos, everything is considered as an evidence of that particular victim or an accused. Anything, yes, definitely.
Any other questions from the participants? I guess we are done for the day.
No problem, no problem. And in case if there is anything which comes up later, you all have my email ID. You can ask me questions there. No problem.
Absolutely. Yeah, as you have mentioned your email ID, I think everyone will contact you if they have any query.
No problem.
So now it's the end of the webinar. So I thank you. Thank you all the participants for joining this webinar. As webinar is nothing without any participant. So, and thank you so much, ma'am, for taking out time, ma'am.
Thank you so